Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We are dealing with a Motor Vehicles Act case in which the defense of vis measure or act of God not accepted, and also the importance of section 149 of the MVAct is highlighted, that is duty of the insurer to satisfy the judgment of the court. Two important aspects have been discussed in this case law. So definitely you have to know, particularly the law of tort students. In a claim under section 163A of Motor Vehicle Act, no necessity to prove death due to wrongful act of the vehicle owner. We can say it's no fault liability. This is a decision given by High Court of Sikkim, Justice Meenakshi Madan Rai of Sikkim High Court in the case of National Insurance Company Limited versus Nim Tshering Sherpa, Nim Tshering Tshering Sherpa Sherp and others. So this is Motor Claims Appeal number 7/2024, decided on 12/12/2024 by the Justice Meenakshi Madan Rai, wherein she observed that, please remember, when the case is filed under, when the court has given judgment, the insurance company has to oblige the same under 149 clause 2 when the case is filed under 170 of the MVAct. So please remember, in 170 means impleading the insurer. 149 says victims, they have to be fully compensated, and 149 clause 2 duty of the insurer to satisfy the judgments. ఇది కథ. అసలు ఏం జరిగిందో ఒకసారి చూద్దాము. సో హియర్ దిస్ నీమ్ షేరింగ్ షెర్పా వాళ్ళ ఫాదర్ చనిపోయారు. హీఈస్ ద డిసీజ్డ్ పర్సన్, రైట్? ఆన్ 18/9/2011, 2025కి వచ్చాము ఈరోజు మనం. సో 2011 September 18th, the deceased, that is father of Sherpa and others, they were traveling in a Maruti Suzuki this public transport vehicle, కార్లో వెళ్తున్నారు, టూరిస్ట్ ట్యాక్సీలో వెళ్తూ ఉన్నారు. వెళుతున్నప్పుడు ది డ్రైవర్ వాజ్ మిస్టర్ వికాస్ ప్రధాన్. సో సహజంగా కేసు మనం పెడతాము, జరిగిన దానికి పెట్టేదానికి. సహజంగా ఎవరైనా సరే మనం కేసు పెట్టేప్పుడు ద డ్రైవర్ డ్రోవ్ ది వెహికల్ ఇన్ ఎ ర్యాష్ ఆర్ నెగ్లిజెంట్ మేనర్ అంటాం. ఇక్కడ జరిగింది ఏంటంటే, ద వెహికల్ వాజ్ హిట్ బై బౌల్డర్స్ and it turned to a side, went into a valley, fell into a river, and 14 సంవత్సరాల తర్వాత కూడా so far father and others except one person, they are not traced, they are washed away in the river. ఇది భయంకరమైన కథ. సో రాళ్ళు తగిలి బౌల్డర్స్ ఎందుకు? ఎర్త్ క్వేక్ ఇన్ దట్ పర్టికులర్ టైం. అప్పుడు భూకంపం వచ్చింది, ఇతను స్పీడ్గా పోతున్నాడు, సడన్గా రాళ్ళకి తగిలింది, బండి పక్కకి వెళ్ళింది, కింద పడిపోయింది వ్యాలీ, కిందేమో అగాధంలో రివర్ ఉంది, రివర్లో వాళ్ళు కొట్టుకుపోయారు. వన్ పర్సన్, సో ఈజ్ ఆల్సో నీమ్ షెర్పా, హీ సర్వైవ్డ్. ఆయన ఒక్కడే బతికాడు ఈ పల్టీలు కొట్టే కాలంలో. మరి ఎలా? భగవంతుడు అతనికి నూకలు ఉండుంటాయి డెఫినెట్గా. హీ సర్వైవ్డ్, రైట్? సో కాబట్టి so far these persons, father of this our complainant, that is Nim Tshering Sherpa, was also. So 11 years passed but not traced, right? Ikkada. So son of Tshering, that is present unnadu kada, Nim Tshering Sherpa, he filed a case of compensation under MVAct, stating that as the driver of the vehicle, because Pradhan drove it in a rash or negligent manner, this incident happened, coupled with the so-called earthquake. Insurance company, they say that the driver is a qualified person, driver is having valid driving license. At the time, because of the earthquake, this accident happened. This is vis major. Since it is vis major, we need not pay any compensation. Then, as far as the owner of the vehicle is concerned, Owner said the vehicle was properly maintained, taken the fitness certificate by the regional transport authorities, and the driver is also a qualified person. Therefore, we need not pay any insurance because it is an inevitable, it is act of God. But the tribunal, MACT, Motor Accidents Claims Tribunal, they held that this man, since the deceased was earning 10,000 rupees per month, and basing on the strict liability, they have accounted the compensation to a tune of 14.4 lakhs, 14.4 lakhs and others, and asked the insurance company to pay. Insurance company says, when it is an act of God, West measure, so we will be exempted or will be accepted from the liability. But court said, according to 149 clause 2 of the MVAct, you have to satisfy the judgment of the court even though you are not liable. This is the concept of strict liability. And the court clearly stated that when there is no specific order under 170 MVAct, definitely when the appeal grounds are on 149 clause 2, you have to satisfy the judgment because already a person died. The reason is rash or negligent act of the driver coupled with the earthquake. Valuable life of a person is lost. So therefore, you have to satisfy the judgment. They have to be fully compensated. In such cases, we are not, of course, we are not worried. We cannot blame the driver for his rash or negligence, but still, since the death is there, you have to pay the compensation. Very good judgment. Normally, in such cases, this major act of God law, exception can వెళ్ళిపోతారు కాకుండా the court based on so many other case laws already 7 నిమిషాలు ఇక్కడ చెప్పట్లేదు. So definitely came to the conclusion that you have to pay compensation. Very good judgment. Read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.